Okay, good afternoon, everyone. My name is Sebastiano Toffaletti. I'm Secretary General of the European Digital SME Alliance. We are starting now a webinar of the Digital SME Live series, which is with the title IP Dispute Resolution for SMEs, Finding Rapid and Amicable Solutions with the Help of EUIPO. It's 4 p.m. in Brussels, Central European Time. I'm here with some friends from the EUIPO, the European Union Intellectual Patent Office, in particular Sven Stürmann from Germany, who's going to help me go through the topic of today. I just wanted to wait a couple of minutes before we actually give it a start, such that we can allow all participants to dial in. We have had approximately 60 people registered for this webinar, which will also be available which is already available in streaming on our social media channels, Facebook, YouTube, and Twitter, and will remain available on our YouTube channel later on. So 1 minute after 4, I would like to slowly start with a very short introduction of the topic. With the pandemic, with the COVID-19 crisis, as you certainly know, many SMEs have had, serious economic repercussions. In Europe, we have our political masters have agreed on a substantial recovery package, and very many different measures are being put in place by the national countries as much as by the EU in order to support the SMEs, the small and medium-sized enterprises. Because indeed, we do acknowledge that these companies are the greatest source of Europe's growth, the greatest source of Europe's employment as well, which is indeed very important. So at the time of this crisis, the European Union Intellectual Property Office, the EUIPO, decided to offer SMEs a special online service. They call it a COVID-19 special online service to settle their intellectual property disputes. So rather than entering into expensive and long-term legal disputes, SMEs can find a cheaper, quicker, and easier way to solve their IP-related disputes with the help of experts. So the mechanism called Effective Dispute Resolution, EDR, is in place to help settle disputes by using effective alternative dispute resolution mechanisms, which have been used along the year, and they are quite well rolled out. How does it work? What can concretely SMEs request the EUIPO to do for them? To understand better the service and to understand better how the EUIPO works, we have invited Mr. Sven Stürmann, who's indeed a lawyer, as you can imagine, but he is also a very experienced mediator himself, and is indeed a member of the EUIPO, where he chairs the second Board of Appeal. Together with us and next to Sven, we have another couple of very distinguished colleagues of Sven. In particular, we should have Gordon Humphreys and Theophile Margelos. Both Gordon and Theophile work for the EUIPO. Mr. Margelos is president of the Board of Appeal, and Mr. Humphreys is chairman of the first Board of Appeal chairman of the first Board of Appeal in the EUIPO. So the three of them are very experienced mediators, and the three of them gave their availability today to come to this, to participate in this event and speak to all of us and let us understand. So we'll shortly give the floor to Sven, who's gonna give a first introduction of what EUIPO does for SMEs. And after that, we'll open up the floor for questions. I believe everyone should have understood how the system works. There's a possibility to raise hand or even to use the chat function to ask a question. Preferably, you can raise your hand and I'll give you the floor once the presentation of Sven has been concluded. So Sven, with all this, the floor is yours.
Okay. Good afternoon, first of all, to all of you listening, and Sebastiano, thank you very much for your invitation, first of all, and for your kind introduction. I think you have very well explained what I want to talk about, and you have set the scene. This is great, and then I can immediately start with the substance. As Sebastiano has said, we want to present you our effective digital resolution service we are offering now, in particular for SMEs, because many SMEs in these difficult times may need this support, and that's the reason why we have set up this service, and the idea is to go into details. But before I explain this service in more detail, I would like to briefly introduce you into our office and what we are actually doing. So we have, since the existence of our office in 1996, registered more than 2 million trademarks, more than 1.4 million designs. We are a huge office with more than 1,000 staff members coming from all the member states of the European Union. We are self-financed, and very important, we are cooperating in all our business areas, not only with the trademark and designs and other IP offices in the EU, but also outside. Okay, so basically the EUIPO is responsible for registering trademarks and designs. But the question is, what are actually trademarks and designs? And I would assume that many of you know it, but some may not or not be so familiar with it. Therefore, I have included into my presentation some few slides in order to explain you exactly what trademarks and designs are. Let's start with trademark. What is a trademark? A trademark is a sign used in trade to identify products. And your trademark you are designing, inventing, is the symbol your customers use to pick you out. And it distinguishes you from your competitors. And very important, you can, and I would even dare to say you should, protect and build upon your trademark if you registered it. You have here an example. On the left hand, you see a daily product, which is yogurt. And I would think that we all agree that if you saw that in a supermarket, you wouldn't be very inclined to buy it, because you don't know exactly who's behind this product, and it's not very appealing. However, if you add a trademark, a brand, as you see on the right hand here in the slide, then the whole thing becomes different, and you actually now identify the origin of that yogurt product. So that's the core essence and the core function of a trademark, and it's very powerful, as you can see in the following slides, where I've added some example which I think we are all familiar with. These are figurative and word marks which have been registered and which have been very successful in the market. And therefore, it's very important also from the very beginning, because if you are a startup or if you have just initiated your business or commercial activities, I think it's still very important to register trademarks at the early stage possible. Our office is responsible for the registration of these trademarks at EU level, because you can register trademark at the EU level or at national level. Other examples for trademarks you can find here. You can actually file you can register a three-dimensional trademarks. These are products, the shape of a product or the shape of a packaging. Again, examples which I think we all very well know. And I would say the success of these products is in part due to have registered these things as a trademark. Here you see another example of trademarks which can be registered, which are either color per se or color combinations. And as we are now here in a very digital environment, I of course need to show you one of our latest trademark, let's say, possibilities, which is a multimedia trademark. So you can actually apply for a multimedia trademark, which is the combination of sound and image. And I would like to give you a very short example so that you get a feeling of what actually multimedia marks are. You see, this was a multimedia mark, which was applied and registered for different goods. And again, here, the combination of sound and image defines the scope of that trademark. So please don't forget, there are very different types of trademarks which can be interesting for you in order to give your service, in order to give your product a brand. Then, of course, we are also responsible for industrial designs. Designs protect the, let's say, the appearance, the outside appearance of a product. I have added into this slide a couple of examples, which shall show you that also designs can be very powerful, or are very powerful and important intellectual property rights, which you should consider when thinking of protecting your products. But let's now go back to the presentation on effective dispute resolution. As Sebastiano has said, for us, the EUIPO, the European Union Intellectual Property Office, it is very important to support the SMEs in all the different, and they are all different activities. And the effective dispute resolution must be seen in this context of the European Union Intellectual Property Office Strategic Plan 2025, which is focusing on the support of the SMEs. And why is it so? Sebastiano has already said it, because SMEs are the backbone of the EU economy and all the 27 member states. And IP has long been known as a key driver in innovation and growth.
You seem to have some issue with audio, Sven.
Okay, sorry for that. So we continue with the presentation. So important, again, SMEs are the backbone of the economy. In innovation and growth, an SME who own intellectual property rights, such as trademarks, design, also patent, copyright, have almost 32% higher revenue per employee than those who do not. And that's why we have a dedicated SME program, which is set up in the context of the European Union Intellectual Property Strategic Plan I have mentioned before. However, this strategic plan is a long journey of 5 years. And it's also, Sebastian has mentioned it in his introduction, we are now anticipating some of our services, considering the urgent need of providing SME specific services in these difficult times of the COVID crisis. And these services are split into 3 areas. The first one is the EUI website SME Corner. I invite you to visit our website, and then you find a dedicated SME Corner where you get very important practical information on the protection of IP rights for SMEs. Then we have the effective dispute resolution service, which I will now go into more detail. And in addition, we are offering a pro bono legal service. The pro bono legal service is aimed at giving SMEs a free legal advice in all types of IP matters. So whenever you have an IP matter, and you need legal advice, you can contact our colleagues from the Pro Bono service, and they will guide you through the legal issues of your IP matter. And by this, the EUIPO wants to offer a 360-degree service to the SMEs in order to help them to manage different legal aspects of their disputes. Now, coming to the effective dispute resolution, here the focus, different to the pro bono legal service, is not on the legal issues, but on the commercial and business interests of the SME. So what we want to do is, we want to support you in settling IP disputes, looking at the commercial interests of the parties. So that's very important. The legal, pro bono legal advice, focus on legal questions, on all types. The effective dispute resolution comes into play when you are involved in a dispute and you would like to settle that dispute instead of risking long-standing and costly court proceedings. The processes we are offering are mediation, conciliation, assisted negotiation, and expert determination. I will now explain in detail what these proceedings are about. But let me so remind again, why is this EDR service interesting for you? So I said it, Sebastiano has also said it. It's quicker, cheaper, and much more efficient, because we will guarantee you to give a global solution to the dispute so that you don't have to litigate during many years. And we want to avoid complex litigation proceedings, because these proceedings drain resources and they act as an obstacle to your business. That's why we are convinced that we should offer you a kind of guided dispute resolution service. We also offer you to combine parallel proceedings, because sometimes you might be involved in a procedure, in a dispute before the EUIPO, but at the same time you have a dispute with the same party in another country, either in Europe or elsewhere, or over another intellectual property right. I give you an example. Very often when the parties are involved in trademark disputes, at the same time they also are involved in domain name disputes. So all this can be settled in one mediation, for example. And all these processes, we are offering them remotely. So we are flexible and we will consider the needs of the parties. So we will check by email, we will use email, telephone, MS Teams, Zoom, or other IT tools which are available for you. How does it work on the practical side, the effective dispute resolution service? Again, it's pretty easy and straightforward. On our website, you will find a web-based form which you need to fill in, but I promise you, these are 3-4 fields, very easy to fill in, and it will not take longer than 5 or 10 minutes. Then, once we have received this request form from you, we will immediately designate a so-called EDR, effective dispute resolution case handler, who will also immediately contact you by telephone, email, whatever you have indicated in the form. And then we will set up a conference call of 1 or 2 hours. And we want to try to find out together with you what the commercial issues are behind your dispute. And then at the end of these discussions, we will give you a recommendation how this dispute could be settled with the other party. And that could be mediation, conciliation, assisted negotiation, or expert determination. Should you agree with one of these recommendations, we would then contact the other party. And if the other party also agrees with one of these mechanisms, then we would actually launch the phase 2 with then the actual dispute resolution process, as for example, mediation or conciliation. But maybe I've talked a lot about conciliation, mediation. I think I need now to explain to you what it is all about. Mediation is a process in which parties to a dispute, guided by a mediator, reach an amicable settlement of their differences. The parties, with the support of the mediator, will attempt to identify common ground and business interest that may be explored in order to settle the dispute. Then we have conciliation. Here we have a conciliator who is able to suggest own possible solutions to the dispute. The difference between mediation and conciliation is that that in the mediation, the mediator has a role of a moderator, and he discusses with the parties and he encourages the parties to find their own solutions. Whereas in the conciliation, here the conciliator has a more proactive role, and he or she can actually propose a solution. He can come up with his own or her own ideas how this dispute could be settled. Very important, in both processes, it is absolutely voluntary, and it requires the consent of all parties to the dispute. We are also offering assisted negotiation. Assisted negotiation is a process in which an impartial facilitator will coach you in your direct negotiations with the other parties to reach an amicable settlement. So the facilitator takes tasks, includes assessing the underlying circumstances of the dispute, to coach you on appropriate strategies and techniques for negotiation, and engage in an effective dialogue with the other party. So the focus is here that you as an SME has decided that you want to negotiate alone with the other party, but that you would like someone, let's say it, in the shadow to support you by assisting you in the negotiation. The last mechanism we are now offering is expert determination. Here, the process in which an expert appointed by the parties gives a binding or non-binding opinion on legal or technical matters. That is, the focus here is different. It's not primarily aimed at solving a global dispute, but to settle a part of a specific dispute you are involved in. And very important, all these four mechanisms, mediation, conciliation, assisted negotiation, expert determination, can be combined. We call that hybrid processes. And here, the possible use of hybrids will be discussed and decided during the course of one of the main processes. So for example, we can use expert determination in combination with mediation in a point where the mediation is stuck because a legal or factual question needs to be settled and determined. Here, that can be very helpful. We have done it in the past. The expert can be of great help. Last, all the mediators are employed at the EUIPO and are internationally accredited and senior IP lawyers. The same goes for our expert and facilitators. They're all employees of the office and expert in their field and have long-standing negotiation experiences. This table is just to show you again and summarize you the different features I've explained at the previous slides, and I assume that Sebastiano will make available this PowerPoint, and you can here see then on one slide what each process is about and what scope it has. And with this, I finish, and thank you very much. And now, Gordon, Teofilo, and I, we are looking forward to receiving your questions. Thank you very much.
Thank you, Sven. And indeed, we will also make available your presentation with your agreement on our website, on digitalsme.eu, for anyone who's interested, along with you know, the video of this conversation. Now, with this, indeed, as you said, it's not just you who are here today, but we have Teofil Margelos and Gordon Humphreys, who are also from the EUIPO, also from the Board of Appeal, who are, hello Gordon, who are here also to possibly help us responding to questions from the audience. Everybody can use the chat, so they can write their question on the chat, or they can use the raise hand function if they want to have the floor to make any comment or to ask questions to the colleagues, to the mediators of the EUIPO. So to start with, perhaps I'd like to give the floor to Silvana Marcotulli, who's a person attending this webinar. We know very well Silvana because she is at the same time also the chairman of the working group on legal affairs of the European Digital SME Alliance. So she is probably in a good position also to say something on behalf of the SMEs in her own association and as a chairman of the group. So Silvana,
hello,
I hope
hello.
you can. Yes, hi Silvana.
Hi, hello everybody. Can you hear me?
Yes, we can hear you well. You can go ahead.
Hi, Silvana.
Hi, Sven. First of all, I would like to thank you, Sven, and the EUIPO for this speech and this illustration of the services. I have, of course, I'm an IP lawyer, and I have some question on behalf of the Digital SME companies. First of all, I would like to understand better, is the EDR service, is there any specific stage that maybe a company or a representative of a company can contact EUIPO? I mean, normally when we are talking about trademark, design, so the other company, I mean, maybe can send a notice, no, of counterfeit to the company. How, I mean, the representative of the company can act? Can contact you directly, or we are there is some stage?
Yes.
So how in practice does it work?
Sorry?
Okay,
yes,
Silvana.
I think you can try to reply to Silvana.
Yes, and then I will give the floor to Teofilo and Gordon if they want to add something. I mean, that's first, thank you very much for this question. The effective dispute resolution as we offer it currently is available when one of the SMEs is involved in a procedure before the EUIPO. So you need, in order for us to be able to act as case handlers, as mediators, we need to have a process here before the EUIPO. That means either an opposition, a cancellation, an invalidity, or an appeal. But what is very important, this is then only, let's say, this is the starting point. As I mentioned before, let's say if your client or if the SME, if you are involved in parallel disputes, which are even not pending before the EUIPO, we can still include them. That's very important. We need a starting point with the EUIPO proceedings, but once we have this starting point, either, for example, a first instance opposition, let's say, then if the parties are involved in other proceedings, even before other offices or whatever type of conflict they have, they can include it. But we need a starting point at the EUIPO.
Okay, but you mentioned also that there is a pro bono services. In
Yes.
this case, I mean, the companies can use the pro bono services in order to obtain some consultant service and understand exactly it's better to do.
Yes, for the pro bono, the situation is indeed different. For example, if you are actually considering filing a design or a trademark or another right, either at the EUIPO or at national level, you can contact the pro bono, and there you can really, let's say, come from scratch from the very start and ask for legal advice. That is possible even if you don't have any trademark even filed at the office. I don't know, Gordon, do you maybe want to add something on this pro bono?
Yeah, we need to unmute Gordon, I suppose. Just a second. Try now, Gordon.
Oh, it doesn't work.
Think...
Okay, Gordon, try to fix it, and if you just talk, when we hear you, we give you the floor. So as I said, yeah, the pro bono, this is a very good question, because we have the pro bono, which starts from the very beginning. Whenever you have any legal issue in any IP right, even if it's in the first stage that you even want to get some advice how to file a trademark, a design, you can use this service. For the EDR, because here we have two parties, we need first an opposition at the EUIPO or an appeal pending.
Okay, I don't know what, can you hear me?
Yes.
Can you hear me now?
Okay.
Good. Yeah, I was just going to add that, I mean, on the pro bono, as Sven's just said, I think we've more or less covered it. perhaps, I mean, what's interesting to know is that if obviously this service was designed in the first place because of the financial consequences that now the whole world is going through because of the pandemic. And as a result, we've also opened up the possibility of unrepresented individuals or SMEs being able to contact the EUIPO, even at a very early stage, what we call the cooling off period, which is the period just after an opposition has been filed. These either individuals or company representatives if they don't have a representative, they can, if they don't have a lawyer or trademark agent, they can get in touch with us and avail of our services even at this very early stage. Thanks.
But if you allow me, Gordon, if you allow me, Sebastian, that was a very important point. And I would also say, because this is very technical, and I also understand that in 5 minutes, it's this service is quite complex, I have to say. But don't worry about it, because if you see our web-based form, it doesn't matter what you just explain us what your problem is, and then it goes to us, and then we will decide, look, dear SME, this is rather for our pro bono colleagues, and you need legal advice. Or we say, look, actually, this is for our colleagues Gordon and Sven on effective dispute resolution. So what I want to say, even if it is complex, and please ask us further questions if you have, but even if you don't really understand the scope of the two services, it doesn't matter, because you will see the web-based form is so easy. We will just ask you, what's your problem? What do you need? How can we help you? And then you explain it, and we will tell you and recommend you, I think you should go to a lawyer, or no, better you go to our colleague from EDR to solve the dispute.
Okay.
Right. And let me also ask you a question I had while you presented, because if I understand the service, I mean, EUIPO is able to serve in what is it, 9 languages, so it's quite impressive. But these particular services, when you want to address specifically to SMEs, and they may be offered also pro bono, how would you distinguish if an SME is European or non-European, or would it be open to everyone, member of the EU, no member of the EU? Do you have a rule for that, and how would you do in practice?
Yeah, I mean, here I'm afraid I have a clear answer for
Good.
this service I mentioned. No, it's good, because, but I mean, I know you told me that we have some people listening from outside the EU, and for them maybe the answer is not so good, because it was decided that this very specific service on pro bono and EDR can only be offered to SMEs who have a seat within the European Union. Yeah, that's a very good question, Sebastian, and I thank you for that question, because I didn't mention it, but yes, it can only be offered for SMEs having a seat in the European Union.
Yeah, I don't want to make it too difficult now, but because it's important for us to understand this, because we, as the European Digital SME Alliance, we have members also in neighboring countries, okay, which are not formally members of the EU, but maybe they are in negotiation, or they have a status as a neighboring countries of the EU. Do you know? I mean, it's going to be probably case by case, but do you have an idea what should these people or companies from those countries expect?
I mean, what you can do, let's say, in order to launch the service, especially the effective dispute resolution, we need again an SME who has a seat in the EU. But if, for example, let's imagine we have an SME, let's say from Poland, right? And then we have another, and they have actually a conflict of an SME which is in, let's say, in Russia, for example. Okay, so
Good
the SME
example.
in Poland, yeah, that's a very updated. So the Polish SME can ask for this support service. And let's say if we go into phase 2, where we would actually do the mediation and the conciliation, that could be done also with a party which is not in the EU. But let's say the first phase, it can only be requested by an SME in having its seat in the EU.
Could I just add something very quickly, that in fact we've already had a case involving a Spanish company which has an ongoing dispute in China because they're exporting to China. So this is really, we have actual examples of this, right, because China's a huge market and SMEs are very interested in it.
Okay, okay, I understood. Silvana.
Sorry. Yeah, with this regard, what is the enforceability? I mean, especially when the two companies are, one is a EU company, another Chinese company. The enforceability of the settlement, this is very important. No? As you mentioned, you want to help these SMEs to solve the disputes globally, no? So, I mean, otherwise, and what is the value? I mean, the enforceability of the settlement. I understand that if just an amicable settlement is on the parties, I mean, you know, on the will of the parties, because it's just a contract. I mean, but in case of in the phase 2, the ADR, I mean, the alternative dispute resolution. How, I mean, the Spanish company can obtain a result in China, I mean, enforce the decision in China?
This is a very good question, Silvana, because you have, first of all, as you correctly said, the settlement the parties reach independently if they're from the EU or outside the EU, that will be always a private agreement. So you have to enforce it if necessary. And that's why we want to do with mediation, because our experience is that there's no need for enforcement. But if it's needed, the enforcement, then you would need to enforce it according to the rules of international private law. But that's why we also have the Singapore Convention. You know that you may have heard that very recently the United Nations has established a new convention. This is the Singapore Convention, and that actually allows you to enforce mediation agreements in different countries. Unfortunately, the EU is not yet member of this convention, but they are negotiating it. We are all we know that the EU is not so easy on the lawmaking side, as we have a lot of different member states. But I can tell you, for example, a mediation agreement in the United States can be enforced in Singapore and vice versa. So we now need to be the EU part of this agreement, and then it would be easier. But as for the time being, as you said, it's considered a private contract between the party, which needs, if necessary at all, to be enforced according to international private law. Gordon, I think he's okay. Good.
Yes.
Yeah. Can you?
Teofilo.
Teofilo, you have the wrong name, but you look like Gordon, but you are not Gordon. And I'm afraid you are also muted. So you should unmute yourself.
Okay.
No, I'm afraid.
Gordon, you wanted to say something, no? Gordon?
Yeah. Yes, I was just going to say that in fact,
Do you
China
hear me now?
is a. Okay.
Yes, we can hear you both now.
Okay.
Teofilo, please.
Yeah, okay, go on, Gordon. I'll take out.
Okay. Yes, I was just going to say that China's a signatory to the Singapore Convention, and of course that's why it would since China and the USA are members of this Singapore Mediation Convention, it really is a very important international treaty, and one which we would be well advised to sign up to. Go ahead, please.
Okay,
Yes.
do you hear me now?
Indeed.
Yeah, okay. Thank you very much. Hello, Sebastiano. Thank you very much. Hello, Silvana. Thank you very much for organizing this. It's really very interesting. I would like to come back to the questions, and Sven said that okay, it's quite complicated. Indeed, it's quite complicated, but finally for you is not so complicated. Whatever is your problem, you have just to contact us, and then we're going to look with you the problem, and we're going to tell you, okay, we can help you or we can't help you. So just refer to the example of infringement given by Silvana. If you are in infringement before the national courts and has to do with the European design or European trademark, that's a sufficient good contact for us to try to help you. So maybe you are in infringement and you want to negotiate. Then you have the assisted negotiation as a tool which will help you to negotiate with the other party, or at least to try and negotiate with the other party, and that can be very useful. So you may also consult us if you want to say, what I'm doing now. I have an infringement action, what I am supposed to do now. And then you are going to have some answers. Oh, this is the one answer, but for this you need a lawyer. You can find a lawyer yourself, or you go to pro bono. You want to negotiate, because yes, it seems that it would be better for you to negotiate than to continue through that process, that judicial process. So that's an option for you. We give you the elements that you assess the option and you make a final decision. This is how this is functioning. So right. Concerning then the enforcement of all these things, it's true that it depends of which is the option you are going to take. If you take an expert determination, that means that you need both parties, to have an agreement on this specific tool, which is the expert determination, which focuses. It's like if you are asking the opinion of an expert. So it focuses on this very specific expert point. For instance, for those of your SMEs, of your members who are design intensive, who have designs and protect designs, whether in a specific case, for instance, there is intensity of the art, whether there is a technical or not technical feature. These are specific points which may be relevant for the resolution of the case. So in this, if both you agree, it's you take the expert determination. It depends on the parties whether to make it mandatory, the outcome, or not. You sign a contract, and then it has the force of a contract. Same thing in mediation, and there in mediation, as Sven said, Singapore Convention, when and if it is entered by the European Union, enters in force in the European Union, that will help because it gives flexibility for the enforceability such agreements. So again, the point of contact, even to answer your question also, what happens with our members, with our SMEs, which don't have a seat in European Union, but they are in another country outside of the European Union, but they can have a European trademark.
Right.
Everyone, they can have a design, a European design. That's a sufficient point of contact with us in order to try to help. And in any case, you don't pay nothing. It's there are no costs, no expenses to ask, always. And then you are going to receive an answer. We can help you, or we cannot help you. We can help you, and these are your options. Okay.
Right. That seems very, very clear. Let me go on with a question which has been asked in the chat, in the question box. Let me see if this is a question from Gail Anderson. I can read the question, but maybe she wants to ask the question herself. Let me see if I can unmute. not sure she actually. Okay, let me read the question because I'm not sure she wants to. She's asking she's from company Oxycom. She's asking, can you help us in a dispute with the UK in the Brexit context, or even with the US? What would be your reply in that case?
Oh, that's for you. You are our British.
Gordon.
Yeah, for my sins, yes. Okay, so I mean, I'm assuming that it's a dispute between one company based in the EU and another one based in the UK, right?
Okay.
Certainly, we can help. Provided that there's something in the EU. At the moment, we can help up until the 31st of January, even if it's sorry, the 31st of December, even if it's a company from the UK that's asking for our services. So in fact, this is because we're in the transition period. All the EDR and the pro bono is available to UK companies until the end of this year. Regarding disputes that are initiated by a UK company beyond the end of this year, that will obviously be difficult because unfortunately the UK will be out of the EU, and therefore, as Sven said, the services for EU or companies with a seat or presence in the EU. So if the UK or US company has no seat in the EU, then we won't be able to help after the end of this year.
Right. I hope that clarifies.
No, Sebastiano, just to add, and very important, these services, the pro bono and EDR, it's only available for SMEs. Yeah, we need to stress this. It's very important for SME, yeah, and we use the definition of the EU Commission. It must be EU, and yeah, okay. Good.
She clarified they are from France, by the way, so totally eligible, I believe.
Yes,
we
totally.
have also Emilio Posca. I don't know if Emilio, you should be unmuted. Yes, Emilio.
Okay, just a question, Sebastiano. If this support is valid only for Europe or also just for national issues? I mean, if I have an issues in Italy, I can ask to you to support us, even if it's just limited to Italy, let me say. Not for you.
Teofilo?
Yes, okay. I may answer this. It depends what kind of issue you have in Italy. If you have a purely national issue because it concerns an Italian trademark on an Italian registered design, we can try to help you, but it doesn't serve a lot. We cannot do a lot for you. On the contrary, if you have in Italy a case concerning a European design, a European trademark, for instance, you have an infringement case before an Italian court concerning a European trademark or a European design, then we can help you with this and also all the other parallel maybe conflicts and disputes you have concerning license, concerning also another eventually national trademark you have. So, because if you choose for mediation, mediation is a global approach, and then you put in the basket all possible disputes and conflicts. But if it is just purely national, concerning just a national trademark or national design, and limited to this frame, okay, we would like to help you, but we cannot do a lot for you.
What can I just add? What we
there's one thing we need to mention. I mean, if you have a legal question which concerns the Italian trademark law, the Italian office, you can use the pro bono. So Teofilo was referring to the effective dispute resolution. That's different.
Yes.
But for the pro bono, you can come with questions regarding national trademarks as well, because we have pro bono lawyers which are from Italy, and they can of course support you. Yeah, it's not for the effective dispute resolution, but for the pro bono, when you want to have a pure legal advice, you can contact us with the web-based form, and then we will get in contact with the pro bono Italian lawyer who can support you for the national legal issues.
Mm-hmm.
Let me ask maybe a silly question here, but just to be 100% sure. You are, this help we may only concern issues related to trademark and design, or would it be also possibly concerning patents?
Yes.
Because I know the EUIPO is predominantly for one, but
okay, so let's start with that question that was tie it into the previous question, which was about if it's purely national. So you could get the pro bono lawyer for any IP dispute, patents, copyright, design, and trademarks, right? And by the way, we haven't said what pro bono means in case anybody has any doubt. It means not asking for fees or a very reduced fee. So essentially, a lawyer that's willing to work for either for free or for a very low fee for SMEs. Yeah, for free. Yeah, for free. Okay. So then the next issue about the EDR is, as Sven said, I think in the presentation, that provided you have a dispute before the EUIPO involving either a trademark or a design, then you can bring in other IP rights that you also which are also involved in the dispute, provided of course they're with the disputes with the same party. So as Sven said, if you had a domain name that was being disputed as well as the trademark, we could also look at the domain name, and theoretically, if you had a patent, if there was a patent that was in dispute and the trademark on that patent was also in dispute, you could bring that in as well. So we could open it up to absolutely all IP rights, even plant varieties.
That's quite interesting from my point of view, because indeed we as an association, we represent technology companies, digital SMEs, and indeed there are going to be certainly a lot of trademarks out there, but in this particular field, we believe many companies are actually using also patents to protect or to somehow generate revenues from their inventions, and therefore the availability of the service in also covering patents is quite interesting from my point of view.
But sorry, Sebastiano, just to be clear, I mean, if I understood well, you have in any case a dispute on trademark and design, and then you can broaden, I mean, the dispute to the patents and copyright and domain name. It is correct?
Yes.
Because yes, it has to be clear for our companies. I mean, for the companies in general. If you are just a dispute on patent, I mean, I don't think that you can use the services. It is correct. You can
use the pro bono.
But you can use then, this is Silvana, this is absolutely correct. You can't use the effective dispute resolution because you need the link to the EUIPO, but you can ask for the pro bono legal free advice, as Gordon has explained. So for patent, it's only the pro bono legal advice, and they can help you to run the dispute.
Oh, great.
Okay, look, if I may come in, do you hear me?
Yes, please.
Oh, okay. Just to give you an example, a product may include a lot of IP rights, and normally it includes a lot of IP rights. A trademark, which are the product, the brand, a design, because a product has an appearance, so there is a design, and the product has a use, a technical use, and that is the patent. And maybe this is also the technical aspect, and the design are covered by copyright or by a business secret. trade secret, by a trade secret. So all these are IP rights. And if you have then a dispute concerning that product, okay, normally this dispute will involve all these IP rights. So if the trademark is a European one, and then you come to us and say, look, I'm fed up with all these processes, with all court judges, lawyers, and exchanging reads, papers, and before the court, and so on. I want to negotiate, or I want to find another way of doing things, whether it is conciliation, whether it is mediation, whether it is a negotiation. So what you need is to find out your way in order to avoid very expensive and time-consuming and processes and judicial conflicts, which don't allow you to continue putting the products on the market and exploit the business possibility you have. Then you come to us because you have a European trademark. And then when we discuss the case, we need to take globally into consideration everything which is in the basket, the copyright, the patent, the design, and the EU trademark, for instance. And then together we're going to find a possible option. So that involves a lot of IP rights. On the other hand, if you have, as Gordon says, or Silvana also, just a patent question, how to draft, for instance, the claims in a patent application, that we can't help you. Maybe our pro bono lawyers may help you, although our pro bono lawyers are, in the big majority, trademark and design attorneys. Okay, you need to take this into consideration.
Right.
But then the pro bono can maybe help you. Okay, I hope that this example has clarified some, answered some questions.
Let me ask you another question that comes from a person who's following us on YouTube, not here in the webinar. She's Anna Bopol. She's following from Belarus, a country that we mentioned before, and then we also send her and all the people in the Belarus our best wishes and best regards for the difficult situation they are living right now. Anna is asking if, in particular, there is any specifics of dispute resolution for companies in the digital markets. Maybe it's a difficult question. I don't know if some of you wants to try to reply to Anna.
What do you mean by specifics?
The specificities are twofold. First, I mean, as I said before, we are offering everything online. So this is one I could imagine one aspect she was addressing. So you don't have to come to Alicante, you don't have to come anywhere. You do it online as we do right now. When it comes, let's say, to the content of the dispute, okay, I mean, you need to know that we are dealing with designs, with trademarks in all different economic areas, of course, including digital area. So we are familiar with the digital business, and I think we have a quite good understanding of the digital business, which will then also help you, and where we will help you to, or help us to understand you and to support you in settling the dispute.
Right.
But if you have a follow-up question, please, if it's not clear, you can ask to follow up.
Yeah, let's see, because she's typing.
Sebastiano,
yes.
Soon we're going to have a platform where we can do mediation online and also oral hearings online. That is, if an SME doesn't want to go through, I don't know, a lawyer or submit a defense or observations by written, they can ask to do this in an oral hearing. And that could be through that platform. And since we're going to have that platform in the future, with that platform, we can use it also for doing EDR, effective dispute resolution, through that platform. That will give us a lot of possibilities to interact with SMEs. And we hope that everything goes well to have it in around 2 months before 2021.
Yeah,
All
Sebastiano,
right.
could I
Yes,
just
please,
add in quickly
Gordon.
that in fact a couple of weeks ago I was involved in a mediation between an SME in the UK and a Silicon Valley giant. It was a real David and Goliath situation.
Yeah, we see these cases up sometimes.
And this was quite technical, and it was all in fact mainly computer hardware. But you know, sometimes we need, I mean, obviously the parties have to explain to us their business, but we have to be very flexible. One day we can be talking about cosmetics and the pharmaceutical industry, and the next day we're in Silicon Valley, but we have to be versatile. And the great thing, to tie it into what Sven was saying, is that because we're doing everything online, we can now directly engage with, you know, between Europe and Silicon Valley. It's a 9-hour time difference. That's quite tough on the mediator, but it can be done.
Right. It's already past 5 o'clock, so we should be actually wrapping up. I would like to thank you very much, Sven, and also Gordon and Teofilo for your time, for your availability. I think the main message for me, and I hope also from the people who follow us, is that the EUIPO, yes, it's an agency, it's an institution of the EU, but it's also people, and you are there, and you are very much available and friendly, especially with the SMEs, because you believe that you have a role in helping these companies. So thank you again. With that, I think we conclude today's episode of Digital SME Live IP Resolution for SMEs with the help of the EUIPO. As we said, a recording of the live stream will be available on our website, on the social media channels. Next week, we will meet again for another event, which is going to be about ICT standardization. So another interesting topic for those of you who want to follow us. Thank you very much, and goodbye, everyone.
Goodbye.
Thank you. Thank you. Goodbye.
Goodbye. Thank you.